matter of General Dynamic United Kingdom Limited and the State of Libya.
May it please your lordships, in this matter I appear for the appellants with my learned friend Mr. Riddell, and the respondent's State of Libya is represented by Mr. Davis, Queen's Counsel, and Mr. Bastin. As your lordships know, this is General Dynamic's appeal against the order of Lord Justice Males, then in the Commercial Court, made on the 21st of January 2019. The learned judge held that an order granting permission to enforce the arbitral award in the same manner as a judgment had to be served on the state through the diplomatic channel identified in Section 12.1 of the State Immunity Act 1978. He also held that the court had no power to dispense with service, even though he considered the circumstances relating to the state of Libya to be exceptional. Lord Justice Males's conclusion that the court could not dispense with service against a state produces, as he recognised, a conflict of first instance decisions on the point. As your lordships will have seen, Mr. Andrew Henshaw, Queen's Counsel, sitting as a judge of the High Court, concluded in the Lloyd's Underwriters against Syria case that the court did have the power to dispense with service, and that was followed by Mr. Justice Teare, both in the Havelish against Iran case and also in the present case, when the matter was first dealt with by him on a without notice basis. I propose to address three matters in the course of my submissions. First, the proper construction of the 1978 Act. Secondly, its interaction with applications under CPR 62.18. And thirdly, our response to the points made by the judge and by my learned friend against our construction. Before turning to those three matters, I think it would be helpful to put the issues in this appeal in context. And that's because while some of the issues are specific to the enforcement of arbitral awards, others are not, and it may therefore be helpful for your lordships to understand the different factual situations in which the issues might arise, and therefore the impact which your lordship's decision will have. And I can do that by examining the consequences of Lord Justice Males's decision. Now, as regards the facts of the present case, the judge was clearly unhappy with the conclusion that he felt constrained to reach. He described it in the final paragraph of his judgment as an unsatisfactory outcome, which would at best, he said, produce considerable delay, despite the established policy of the law to promote the speedy and effective enforcement of arbitration awards. The judge described the considerable delay as being at best because he had already referred to the view of the Foreign and Commonwealth Office in this case, that service of documents on the Foreign Ministry in Libya was not at all straightforward and dangerous and potentially not possible at all. And that was something that was recorded in the evidence before the judge. However, Lord Justice Males concluded that this unsatisfactory outcome was the consequence of states being different from other litigants, and he prayed in aid, as your lordships will have seen, the advice from Psalm 146 attributed to King David about not putting one's trust in princes. Yet, Lord Justice Males's decision that it's not possible to dispense with service has wide-reaching consequences that cannot, on any view, be justified or avoided by adhering to King David's advice. And that is because the need to serve proceedings on a state does not only arise when seeking to enforce an arbitral award, or even more generally in a case of a commercial contract which a party has willingly entered into with a state. And the authorities show that many other scenarios can arise. And let me mention just a couple of the authorities at this point which illustrate this. The first example I wanted to mention is the Havelish against Iran case. There's no need to turn it up unless you would find that helpful, but it's in Authorities Bundle 2 at tab 22. Now, in that case, personal representatives of the victims of the 9/11 attacks had obtained a judgment in the US against Iran, which was found by the US District Court to have been complicit in the attacks. The claimants sought to enforce their judgment in the UK against Iranian assets here. And the evidence before the court demonstrated that Iran had a deliberate policy of not accepting papers and was determined to obstruct service. And as I've already indicated, the matter came before Mr. Justice Teare, and he dispensed with the need for service. But if he was
pausing there, presumably Iran had taken no part in the proceedings in the United States.
That's my understanding, my lord, yes.
Yes, and took no part in the proceedings here.
Correct, my lord, yes. So Mr. Justice Teare dispensed with the need for service, but if he was wrong to do so because there is no power to do so, then Iran's policy of obstruction would have had its desired effect. And that case had nothing to do with putting trust in princes, and its facts illustrate clearly the far-reaching consequences of your lordship's decision in the present case. Now, although Havlish was concerned with a terrorist attack abroad and enforcement of a US judgment, the service issue would be just as critical if the action had concerned terrorist incidents in London and direct proceedings against any state alleged to have been complicit. And I would also add that although the Havlish case concerned a state that had a policy of refusing to accept papers, a state could achieve the same result by introducing legislation that made it unlawful in that state to serve papers through the diplomatic channel. A similar scenario was considered in Embassy of Brazil against De Castro Carqueira, which is an authorities bundle tab 17, but again, no need to turn it up for my purposes. Now, in that case, Mr. Justice Lewis, in the Employment Appeal Tribunal, held that Section 12 of the 1978 Act could not be used if the method of service therein identified was contrary to the law of the state in question. He went on to decide that in the case of Brazil, the prescribed method was not actually prohibited, it was simply not provided for by Brazilian law, and that meant that service of the claim was affected. But we submit it's clear from that authority that if a state went further and prohibited service by the diplomatic channel, then service could not be affected by that means, and no doubt the FCO would in practice not be willing to seek to do so. Service would either have to be dispensed with, or if that is not possible, the foreign state would have engineered immunity from suit. And the next example I wanted to refer to is the decision of Mr. Justice Peter Gibson is in a case called Westminster City Council against Iran. That's in Authorities Bundle 1 at tab 11. At one point in our skeleton argument, in paragraph 19G, we referred to that as a decision of Mr. Justice Peter Smith, but that was an error. It's Mr. Justice Peter Gibson. That case concerned the hostage crisis at the Iranian embassy in London. And during the SAS operation launched to free the hostages, a fire gutted the building. The council incurred costs making the building safe and sought to recover those costs from Iran. Now, first it commenced proceedings in the Queen's Bench Division, but those proceedings were frustrated because process could not be served through the diplomatic channel identified in the 1978 Act. Next, the council sought to register a charge on the property, and at the request of the Chief Land Registrar, the council issued an originating summons, but was then again met with the difficulty of how to serve that summons on the state of Iran. The case came before the court in 1986, and that's important because at that time there was no general power in the rules of court to dispense with service. The general power to do so was introduced into the CPR with effect from the 26th of April 1999. Now, Mr. Justice Peter Gibson held that the court could not therefore rule on the substantive question that had come before the court. He reached his conclusion with no satisfaction. He said he found it disquieting that the Iranian government could frustrate the resolution of court process. And it is clear from his judgment that if he could have found a way to avoid the need for service, whether by way of an ex parte originating summons or by dispensing with service altogether, he would have done so. This authority, we submit, again shows that the service issue arises where proceedings against a state are necessary and even where no trust at all has been reposed in it. And the further point we make is this: we submit it's particularly unsatisfactory to reach the conclusion that a state should be able to use the service provisions of the 1978 Act to create immunity in circumstances where the very purpose of the Act was to move away from absolute immunity, which had existed at common law, to a much more restricted form of state immunity. Fox and Webb, in their book on the law of state immunity, which again I don't need to turn to, but is in Authorities Bundle 2 at tab 26, they make it clear that the purpose of the Act was to codify a restrictive rule of state immunity, which had been adopted in particular by this court in the Trentex case.
Yeah.
And according to Fox and Webb, following the introduction of the Act, those in a legal dispute with the state acting in a non-sovereign capacity were entitled to have the dispute adjudicated upon and resolved by ordinary processes of law. Now, as your lordships I'm sure remember, the Trentex case referred to by Fox and Webb was the 1977 decision in Trentex Trading Corporation against the Central Bank of Nigeria, in which the Court of Appeal, consisting of Lord Denning, Master of the Rolls, and Lord Justices Stevenson and Shaw, concluded that the state bank was not an emanation, arm, alter ego or department of the state, but that even if it was not entitled to immunity from suit in respect of ordinary commercial transactions. Now, of course, if the conclusion that Lord Justice Mells reached is truly mandated by the meaning and effect of Section 12 of the Act, then that is the law, regardless of the unsatisfactory nature of the consequences. But we submit that Lord Justice Mells' construction of the statute is not the correct one, and it is to that issue that I would now like to turn, if I may. At this point, can I therefore invite your Lordship's attention to the Act itself, which is in Authorities Bundle 1 at tab 1. Now, as your Lordships can see, it's an Act that's arranged in 3 parts, although other than needing to refer to Section 22, which is in Part 3, your Lordships are only concerned with Part 1 of the Act, and that's the critical part. Part 1 itself is divided into 4 subparts with separate subheadings. The first subpart is Section 1, and that deals with the general immunity from suit. Then you have Sections 2 to 11, which are the exceptions from immunity. Then you have Sections 12 and 13, which are procedure. And then you have Sections 14 to 17, which are supplementary provisions. So those are the 4 parts of Part 1. Can I then invite your Lordship's attention to Section 1 to begin with? So although, as you see, the Act grants a general immunity in Section 1, that general immunity is subject to the following provisions of this part of this Act. And the relevant provisions we submit are Sections 2 to 11 under the subheading Exceptions from Immunity. Those sections contain a whole series of exceptions where there is no immunity. The material one for our purposes is Section 9, which concerns arbitration. And if I could invite your Lordship's attention specifically to Section 9. And there's one point I should mention about that. The bill in relation to this Act had in fact included a carve-out for enforcement of awards, of arbitration awards. But that carve-out was removed, and the exception to immunity...
From what?
Forgive me, my lord. From the exception from immunity. In other words, enforcement was not going to be part of the exception from immunity.
So absolute immunity was to be applied to any enforcement proceedings.
My lord, yes.
Under the bill.
Indeed. And then that carve-out was taken out when the Act came out, which had the effect, and I don't think this is in dispute, that enforcement of arbitral awards did fall within the exception from immunity, so that there is no immunity, substantive immunity, in respect of enforcement of arbitration awards. And once we submit one of the exceptions in Sections 2 to 11 is engaged, then the state does have no substantive immunity. Next, can I ask your Lordships to consider Section 12 under the separate subheading procedure. That's the section with which your Lordships are concerned on this appeal. Now, in our submission, that section does not impose an additional condition that must be complied with in order for the general immunity to be lost. The only conditions that must be satisfied in order to come within an exception are those set out in Sections 2 to 11. Section 12 is exclusively concerned with procedure, as the subheading makes clear. And the point we make is that it subverts the purpose and scheme of the Act to allow a state to use procedural rules to create an immunity where the Act provided for no substantive immunity, and indeed the very purpose of the Act was to codify the principle of restrictive sovereign immunity. Now, this may be a point of some significance because one of the reasons why the learned judge in the court below gave such precedence to Section 12 is that he incorrectly viewed it as supplying a further condition to the application of an exception to immunity rather than as a procedural matter. And keeping open the State Immunity Act, but can I invite your Lordship's attention just to one paragraph of the judgment, which is to be found in Core Bundle tab 8, and it's page 100 of the bundle. And if your Lordships would be kind enough to look at paragraph 43 at the top of page 100, midway through that paragraph, the learned judge said, "The effect of Section 1, therefore, is that in order for a state to be subject to the jurisdiction of the courts of the United Kingdom, two conditions must be satisfied. The first is that the proceedings are of a kind specified in the exceptions to immunity in 2 to 11. The second is that the state has been served in accordance with the provisions of Section 12, that is to say, through the FCO or in some other manner to which the state has agreed." And so we submit that he was putting forward there two conditions that had to be satisfied. We say that's not quite right on the way that the Act is formulated. And actually, if, as in our case, Section 9 applies, then the state has no substantive immunity, and all that remains is how to deal with the procedural matters dealt with by Section 12. Can I invite your Lordship's attention then back to Section 12 of the Act? Now, that section itself is in 4 parts. First of all, you have 12.1, which concerns service. So that's subsection 1, and that deals with service. Then you have 2 and 3, which go together, sections 12.2 and 3, and they concern what is referred to as entering an appearance, which we would now call acknowledging service without challenging jurisdiction. Then you have subsections 4 and 5, which go together, and they concern what is referred to as judgment in default of appearance, which we now call default judgment. And then you have subsections 6 and 7, which make a number of things clear. First of all, that a state can agree to a different manner of service, that actions in rem and counterclaims are excluded from the section, and that subsection 1 does not affect rules of court for leave to serve out of the jurisdiction. Now, it's helpful at this point also to have in mind what section 22.2 says. So if I could just invite your Lordship's attention to that. That provides that references to entry of appearance and judgment in default of appearance include references to any corresponding procedures. And it's because of that that I refer to acknowledging service and default judgment as the corresponding procedures relevant for the purposes of sections 12.2 to 12.5. Now, going back to section 12 itself.
Do you have any idea what that was intended to be aimed at the time when the Act was passed? Because obviously it's 20 years before the CPR, so it's not as if it were a 1998 Act, one could understand that what they were driving at there was something that was already anticipated as replacing entry of appearance.
My Lord, yes, I take the point, and I don't have an answer to that, and indeed it's a question that's troubled other judges when when a similar point has come up, because it's not at all clear what that was meant to be a reference to. And I don't have the answer as to what might have been in the mind of the draftsperson of the 1978 Act. We haven't been able to ascertain that.
In 1978, we did have the concept of conditional appearance, which might be thought of something different from appearance.
That may be under the RSC. But we're not entirely sure why the draftsperson was interested in corresponding procedures. So can I then, to make my submissions, go back to section 12 itself. Now, in our submission, the critical starting point in terms of an analysis of this section is that this section is drafted referentially, by which we mean it is drafted by reference to the relevant procedural law in England, and therefore in particular to the rules of court. In subsection 1 in particular, it is impossible to know whether a document is, quote, required to be served for instituting proceedings without consulting something else. The Act does not supply the answer to what, if anything, is required to be served for instituting proceedings. Only the rules of court do so. So Parliament must be taken to have wished the answer to whether any document is required to be served for instituting proceedings, and if so, what document, to be supplied by the rules of court. And that is, we submit, put beyond doubt by the fact that there are 3 explicit references to the rules of court in section 12, and they appear in subsections 2, 5 and 7. And there are also several references within section 12 to terms of art under the rules of court. These require regard to be had to the rules of court in order to determine the meaning and effect of those terms. And the terms of art we have in mind are writ, entering an appearance, judgment in default of appearance, counterclaims, actions in rem, and leave to serve process out of the jurisdiction, all of which are referred to in section 12. The next question that arises, therefore, is whether Parliament intended that when an issue of service arose, regard would be had to the rules in court in force as at the date that the issue arose, or the rules of court as they existed in 1978. We submit that common sense tells you that it must be the rules of court as they exist at the time that the issue arises, not the rules of court as they were frozen in time in 1978. Nobody could seriously suggest that when deciding whether any particular document needed to be served for instituting proceedings in 2019, parties and practitioners were to be expected to go to the Inns of Court libraries to track down the RSC from 1978. Parliament must be taken to know that rules of court change year on year, and that by legislating by reference to them, it would be accepting such changes as they introduced from time to time. And that common sense approach to construction, we submit, accords with what Bennion say about the construction.
Why does all this matter in this case?
Well, it matters in this case for this reason, that at one of the points prayed in aid by the judge in respect of his construction was that as things stood in 1978, there was no general power to dispense with service in the rules of court. And so he says, well, that's a factor that has to be taken into account in deciding whether or not the court can dispense with service consistently with section 12 of the Act. And we say that doesn't matter because there is a power in the rules of court now, and there has been for some time. Now, Bennion...
section 12 means that some document relevant to this case has to be served through the Foreign and Commonwealth Office. You submit that you could still dispense with it.
Yes, we have 2 points. One is, first you look at the default rules, and if under the default rules, and I'll come to those, in this case it's 62.18, if nothing is required to be served for instituting proceedings, then you're outside section 12. If under the default rules something is required to be served for instituting proceedings, then you still have the ability under the court rules to dispense with service, and if the court dispenses, then nothing is any longer required to be served for instituting proceedings, and therefore section 12 wouldn't apply. And that's indeed how the other judges who decided the point differently from Lord Justice Mills, that's how they reached their conclusion. They said once the court dispenses, then nothing is required to be served for instituting proceedings in accordance with the procedural law, and therefore there's no need to worry about section 12. Forgive me, my lord.
No, I was going to make your point, the relevance of the point, is to do with the word required, isn't it?
Indeed, absolutely.
Well, I suppose the point is that if there was no provision at the time that the Act was enacted for dispensing with service, even if you're correct about the fact of this being a living text, which depends upon what the position is from day to day, it might affect whether you approach the policy of the Act in a particular way, and whether you give the words a literal interpretation, or as Justice Mail seems to have done, a purposive one.
My Lord,
That could be relevant to that issue.
it could be relevant to that issue, although, as I'll come to, even in 1978, there were rules of court whereby nothing would be required to be served for instituting proceedings. So even at that time, Parliament would have been aware that there were procedures that already existed whereby it wouldn't be necessary to serve something in order to institute proceedings. And so even if you did take a purposive approach to this, we submit that it wouldn't produce a different outcome. So I was just going to make the point, and I think in a sense I've made it, but Bennion does say that if Parliament chooses to legislate referentially, that is often an indication that the reference to the earlier legislation is intended to be ambulatory in nature, in the sense of incorporating later amendments, and I won't go to it now, but it's in Authorities Bundle tab 27 at section 17.9. Now, my Lord, that is also the approach that judges in the commercial court have essentially followed when ascertaining whether a document was required to be served in any particular case. So, for example, in the Westminster City Council against Iran case that I already referred to, Mr. Justice Peter Gibson analysed whether the originating summons was required to be served under the RSC at that time.
Or Mr. Justice Peter Gibson was likely to have been sitting in the commercial court.
It's a Chancery Division case.
Yes, sorry, forgive me. My Lord, you're quite right.
Most of the decisions at first instance are commercial court
They
decisions,
are.
but that one isn't.
But I misspoke, absolutely. But what he was doing was looking at the RSC as they existed at the time that the issue had arisen to see whether or not it had to be done by originating summons or ex parte originating summons and so on. And then in another case, L against Y Regional Government of X, which is Authorities Bundle 1, tab 18, that I think was in the commercial court, Mr. Justice Hamblin, he was looking at a slightly different arbitration point. He was there concerned with an arbitration claim form under Section 42 of the Arbitration Act 1996, which seeks the enforcement of a peremptory order of a tribunal, and the question he was dealing with was whether that fell within Section 12.1 of the Act. And he looked at the CPR in force at the time of the hearing before him, which was in relation to that kind of procedure. It was actually Rule 62.4.
Because the rules, parts 62, and I think it is 62.4, isn't it, provides that arbitration claim forms have to be served.
That's correct.
62.18
is different.
Is different. It's
Indeed.
an exception to that.
Your Lordship is absolutely right. That is absolutely right. And we'll come to 62.18. Yeah. But in the case of 62.4, which Mr. Justice Hamblin was looking at in that case, he did conclude that a document under the default rules was required to be served for instituting proceedings for exactly the reason that my Lord Justice Flaux gives, which is that for that particular arbitration claim form, there was a rule which said this must be served to institute the proceedings. Now, it follows from what I've been saying that we submit that whether a document is required to be served for instituting proceedings within 12.1 can only be answered by or by application of the rules of court as they exist at the time that the question arises. And that is the result which was contemplated by Parliament. And that therefore means that although there was no general power to dispense in 1978, there is such a power now. Your Lordships know that in the case of claim forms, the power to dispense is in CPR 6.16. That requires exceptional circumstances to be shown. In the case of documents other than claim forms, the power is contained in CPR 6.28, and that just provides for a general discretion. Now, I've already made the point that we put our case in two ways. First of all, that if under the default rules there's no document required to be served, then 12.1 is not engaged. Alternatively, if under the default rules it is engaged, then there is, we submit, the ability in the court rules to dispense with service. Now, the essential reason why the learned judge in the court below found against us was because he did not think that Section 12 can be viewed from the perspective, or at least not entirely from the perspective of English procedural law. And your Lordships can see that if you look at his judgment at paragraph 38. Can I invite your Lordships' attention to that? That's back in the core bundle at tab 8. And if you look at, this is page 98 of the bundle, if you look at the end of paragraph 37, the learned judge referred to my submissions about English procedural law, but then in paragraph 38, he said that this was not the correct perspective, and instead what he said was that section 12 contemplated that there would always be some document required to be served for instituting proceedings. And that was the conclusion that he came to. Now we say that the judge was wrong about that. Our submission is that there's no perspective from which to approach section 12 other than English procedural law, in the sense that the language of section 12 requires reference to be made to that procedural law. The judge did not identify any other perspective. What he did was replace the contention that reference must be made to English procedural law with the assertion that there must always be a document that is required to be served for instituting proceedings. We submit that's not actually a different perspective at all. What it amounts to with respect is an example of circular reasoning. It assumes that the answer must be that a document is always required to be served for instituting proceedings, and then supplies that as the perspective from which to work out what is required to be served. And we make a similar complaint about the suggestions in my learned friend's skeleton argument that our case circumvents the mandatory nature of section 12. The section is only mandatory in relation to the documents to which it applies. To say that it's being circumvented is really to beg the question of what is the scope of the application of the section. Now, the answer to the judge's point is that had Parliament wanted to ensure that there would always, in all cases, be a document that was served on the state, section 12.1 would have been drafted entirely differently. It would have said something like, in all cases where proceedings are instituted against a state, there shall be served on that state a document for that purpose in accordance with the following procedure. Instead, it says only that any document required to be served for instituting proceedings shall be served in the prescribed manner. And it's only any document that satisfies both the condition that it's required to be served and the condition that it's for instituting proceedings that must be served in accordance with the special procedure. And indeed, we say that the first word, any, supports the view that there may not always be such a document. And the judge does not attempt in his judgment to explain how the clear words of section 12.1 can be disapplied. And what is more, if your lordships look back at paragraph 38 of his judgment, if you look at the second half of that paragraph, you can see that the judge himself accepted that reference would need to be had to English procedural law in the context of section 12, but he said that this would only be to prescribe the identity of the document to be served, not whether any document needed to be served. So he did accept that you have to look at English procedural law. It's just that he said, well, that's just to find the identity of the document in question, not whether any document has to be served at all. We submit that once it's accepted that Parliament required reference to the procedural law, it's impossible to see why that should not extend both to the question of whether a document must be served to institute proceedings, and if so, to the further question of what document. And indeed, the judge's construction becomes entirely unworkable if you consult the court rules to identify the relevant document, only to find that the rules do not provide for one in a particular case.
Are you going to tell us what the position actually was at the time the bill came into force? Was there a requirement, for example, the claim form had to be served or not served for the purpose of enforcement?
I'm going to come
We're
to
going
that.
to come to that.
Yes.
Thank you.
And I would add on this...
If you're right that the statute's, as it were, ambulatory, as you put it, then in one sense it doesn't matter what the position was in 1978.
That's correct. That is our case.
Because the answer to the judge's point is, well, if you look at procedural law as it is from time to time, and if procedural law as it is now does enable you to initiate proceedings without serving the claim form or without serving any document, then, as you say, it falls out, well, your cases, that therefore falls outside section 12.
Indeed, well.
Because there isn't any document required to be served to initiate the proceedings.
Indeed.
Yeah.
And and that was indeed it's not that we're circumventing or anything of that kind, that was the parliamentary intention. The intention was that this is done by reference to the procedural law, and the procedural law is living, and you have to look at the law as you find it. And I would add that my learned friend is wrong to suggest in his skeleton argument that our case impermissibly seeks to use the CPR to override the primary legislation, which is the way that he puts it. On the contrary, we submit our case gives effect to the primary legislation for the very reason that it is the legislation itself which requires regard to be had to the relevant procedural law. Now, what my learned friend appears to be contending for, and what the judge appears to have done, in effect, is to imply into Section 12 a limitation on the Rules Committee's power to create rules which will determine whether a document is required to be served on a state. And we say such a limitation is not a necessary implication from the language of Section 12. On the contrary, it is inconsistent with it. And there's one further point I should make while showing Your Lordship's paragraph 38 of the judgment, because Your Lordships can see that in the last part of that, or 3 lines up from the bottom of that paragraph, that the learned judge did agree that insofar as procedural law was to be consulted, it was the procedural law as it exists from time to time. He actually said that. And so it would seem that at least on that timing point, there's no substantive disagreement between our case and the analysis of the judge. And the difference really was that he said you consult procedural law for a limited purpose, i.e. to identify the identity of the document that must be served, whereas we say that can't be right, there's no such limitation, and you consult the procedural law generally.
Well, this is quite complicated, so you're putting it now. Perhaps I'm being oversimplistic. I mean, it seems to me, so far as the judge was concerned, it all turned on the proper meaning of the words required to be served, a document required to be served for instituted proceedings. Once you've identified that there is such a document, which he did as a matter of statutory interpretation, well, obviously the rules are subject to that. It's not a question of the rules overriding the statute. The question is, do you give those words a literal interpretation, as you seek to do, or do you give them, as he sought to do, a purposive interpretation? You say you give them a literal interpretation, and so you're looking at what under English procedural law would normally be the initiating document, which is the claim form. He said, well, pursuant to the policy he rightly or wrongly identified as the policy of the Act, no, you treat it as the order. I don't understand this point that somebody's trying to say the procedural rules overrule the statute or the other. I don't understand that point.
My Lord, with respect, we say it's wrong. It's a point that's been made by my learned friend against us. He says that in effect that's what we're trying to do. That's not what we're trying to do. We start with the Act, and as Your Lordship rightly says, it's all a question of what does the Act mean. Yes. One point I would make, though, with respect, is that we wouldn't, I don't think, characterise what we say the Act means as taking a literal or literalistic interpretation. That's.
I'm not using that in a derogatory sense.
No, I'm not. Of course not. But I just mean that we say that this is not just what the words say, but it's also in accordance with other things like the purpose and policy behind the Act. In other words, the Act was designed to implement restrictive sovereign immunity. Yes. The Act was essentially there to set out a number of exceptions to general immunity. You then find Section 12 that's in its own.
I mean, you made this point.
Of course.
I absolutely understand. I think all they, to my mind, what they go to is a rationale for why you do apply a literal interpretation, not a purposive one. I mean, that's how I would view it.
Understood. So, I think the reason for making these observations about paragraph 38 is that it does seem to be an important part of the judge's reasoning here, and it is important we submit to see that he clearly recognised you do have to have regard to the procedural law, that is a necessary part of applying Section 12, for reasons which we say are not really clear. He was only willing to do that as it were, up to a point. But he was effectively saying that whatever the rules say, there will always have to be a document. And of course we say, well, that may simply not be right. Now, my Lord, can I then turn to away from the Act for a moment to deal with the specific context that your Lordships are concerned with on this appeal, which is the enforcement of arbitral awards. Because so far I've been addressing issues that arise obviously both generally and as regards enforcement of arbitral awards, but I now need to focus on the detailed provisions of CPR 62.18 and explain to your Lordships how our case works on the precise language of that rule. Now, we have got photocopies of the rules if your Lordships want them, otherwise I'm happy to use whatever's most convenient.
Well, I mean, I'm sure we'll use white books, but actually it's quite useful to have those because we can mark them up. Speaking only for myself, that is.
I'll hand them up. One of the reasons why it's helpful is there are some provisions we look at in Volume 1, most of the provisions are in Volume 2, so
Yes.
it may be helpful to have them all together.
Thank you very much.
So, my Lords, I start with 62.18, which your Lordships will find right at the back of this clip, the last 2 pages of the clip. It's pages 711 and 712 of Volume 2 of the White Book. And can I just summarise what it provides and go through it, if I may? Under paragraph 1, the application for permission to enforce the award may be made ex parte in a claim form, in an arbitration claim form, and that is subject to paragraph 2, which allows the court to specify parties on whom the claim form must be served. So it is right that absent specific order of the court, the application is instituted by an arbitration claim form, but that claim form is not served because it's dealt with without notice. And unsurprisingly, only if the court requires the arbitration claim form to be served, you then have an acknowledgement of service, which is provided for in paragraph 3, and you have permission to serve out, which is provided for in paragraph 4. Paragraph 5 concerns
what is the policy reason for not requiring the initiating document, that's the claim form, to be served? What is the reason for that?
Our understanding, my Lord, is that this was designed to give effect to an important policy recognised by the authorities for the speedy and efficient enforcement of arbitral awards. And one of the major developments of the law in this context was the New York Convention, which facilitated the international recognition and enforcement of awards. And the whole purpose of having this kind of scheme was designed to ensure that those awards could be speedily enforced internationally.
Do we know, so this came in 2001, is that right? When did this come in?
So,
Amended it was amended in 2001. Do we know when it actually came in?
yes, and I was going to come to that, but let me tell you now, the precursor to this provision, with in effect the same procedure, actually came in. What you had was in 1978, you had royal assent of the 1978 Act, I think on the 20th of July 1978. 4 days later, on the 24th of July, you had the implementation of the first iteration of this procedure for the enforcement of arbitral awards, and I'll come back to what it was under the RSC, but that's the date of it. So it was a matter of 4 days after the royal assent. The Act itself didn't come into force until I think 3 months thereafter. So that's the chronology. So you actually had a procedure like this
So when you say the Act, which Act are you talking
I'm
about?
sorry, the 1978 State Immunity Act. Royal assent 4 days before this procedure comes in. Then this procedure comes in the old RSC, and then 3 months later, the 1978 Act
But this procedure
commences.
This procedure wasn't introduced.
The precursor to this procedure. There was a similar procedure with a where.
Well, hang on a moment, Mr. Toledano, because this procedure, by which you mean 6218, is a general provision about enforcement of awards. It's not just states. It applies to every award against every respondent.
Absolutely. I'm not suggesting.
And so it was triggered, presumably, by by the 1975 Arbitration Act, or what?
Well, I'm not sure I can tell you what triggered it, and I'm not suggesting that this is linked to states. Your Lordship is absolutely right. This is a general provision.
Chronologically.
All I'm saying is chronologically, and I think that was what my Lord.
Going a bit too fast. I understood my Lord the Master of the Rolls' question, namely what was the precursor of this, to be what was the CPR precursor of this. The CPR was introduced in 1999.
My Lord, yes.
Yes.
What you're telling
this
us
is all 2001.
What you're telling us is that there was a provision in the RSC introduced in 1978, which was essentially the same procedure. Is that right?
Yes, that's exactly
I'm
right.
not at all. That's the question that Master of the Rolls
Well,
asked.
I mean,
Forgive me.
I did want to know the origin of this,
And-
I'm content that you tell us that it starts off as one would have expected in the rules of the Supreme Court.
It does, and I can give you the specific.
Can you just give us that? Because we've got
Specific-
some of us still have the 1999 edition of the White Book, which is like a Bible.
I have it too. It was RSC Order 73 Rule 10,
73 Rule 10.
and it came in on the 24th of July 1978. And of course, your Lordships are right to say that when that then first appeared in the CPR, there was a new provision formulated for the CPR, which eventually became 62.18. But for your Lordship's purposes, in a sense, it doesn't matter. What matters is there has been a procedure of this nature. In other words, where you don't serve the arbitration claim form unless the court requires you to do so because an order is made ex parte, and then you apply to set aside the order.
So right from the beginning in 1978,
Indeed.
from the very first time, the claim form to enforce an award was served was ex parte. That's what you're saying.
Yes.
Do we have copies of the RSC 19...
Yes, we've got that.
Rule 10.
Is that Authorities 2? Authorities Bundle tab. Authorities Bundle 1, tab 7. And it's page 3.
Sorry.
And that introduced Rule 10 of Order 73.
This is actually the statutory instrument, isn't it?
It is. You can see from paragraph 4 of the statutory instrument on page 3 that what it did was introduce paragraph 10 of Order 73.
May be made ex parte. Application for leave to enforce may be made ex parte.
Indeed.
But the court may direct the summons to be issued. So it's really almost identical.
It's almost identical, which was the point I was trying to make. And then,
And
then
actually
you come along,
by affidavit, because if it was done ex parte, you didn't have to issue an originating summons. You serve your documents consisting of your affidavit and made your application in that way, isn't it?
that seems to be right, yes.
Yeah, and I think that's clear from the explanatory notes as well.
Yes.
Actually.
And then it's the order that has to be served under sub 4, as you can see.
Yeah.
Well, hang on.
So-
This is a bit different, actually. You have to be quite careful here. Sorry, where was the... So, if you were required So this is actually quite important. If you were required to do it in some other way than by, as my lord has said, an application for leave by affidavit, what you then had to do was to issue a summons. So if you did that, it was the summons then presumably which started the proceedings.
But if you look at sub-rule 10.2, the summons should be originating summons to which no appearance need be entered.
It is different, I think, though, from the present rule, isn't it?
Well, there's no provision, is there, in 73.10 for service of the summons. What's required to be served is always the order. That's
which is the same as the
4, which is the same as 62.18.
Indeed.
So, as my lord says, there isn't a specific provision which is the equivalent of 62.18.2, which provides that the court may specify parties to the arbitration on whom the arbitration claim form must be served.
I mean, it may not make any difference. I think we do need to understand this. So at the moment, under the present regime, in 62.18, and this is your case, what you do is you issue an arbitration claim form, but you don't need to serve it unless the court orders so, and you can initiate it by, as it were, an ex parte procedure.
My lord, yes.
But what you do is, from the outset, you're issuing what's called an arbitration claim form.
Yes.
In the previous regime, what you did effectively was apply for permission to enforce an award by making it by serving an affidavit. Well, obviously, an affidavit doesn't start proceedings as such. I mean, that's the equivalent of seeking leave before you start the proceeding, getting permission to do so. I suppose the equivalent might be an application for permission to commence judicial review proceedings, where the actual judicial review proceedings are commenced when you issue and serve the judicial review. I'm not saying it needs anywhere. It's not a point necessarily against you. I just want to try and understand what it is. So there is a difference there for what it's worth. It seems to me. I'm not quite sure how significant it is at the moment, but it does at the moment seem to me it is. It's true that the summons under CPR 7310 didn't require an appearance, but it did require you to issue an originating process
My lord, yes.
by way of a summons.
Well, I think our case...
Also, the application for leave is supported by affidavit. So the explanatory notes say that an application for leave to enforce an arbitration award may be made ex parte by affidavit instead of by originating summons. Isn't entirely correct, because this provision appears to contemplate that there is an application under section 26 of the 1950 Act supported by an affidavit.
My lord, yes.
So presumably there was some form of
application.
Of application form. It's so long ago I can't now remember whether I ever dealt with these things.
Anyway,
pre-CPR, but no doubt if we looked at Atkins court forms, we might find a form for under section 26 of the Arbitration Act.
and I suppose what happened was when the CPR came in, and they probably abandoned, the process changed, and that's maybe when we get the current claim form. Yeah.
I think our case would be, our argument would be that under both procedures, the process is instituted, the proceedings are instituted at the outset. In the one case under the RSC, they are instituted by the application supported by an affidavit, and in the case of the current CPR, they're instituted by the issue of the arbitration claim form. And in both cases, you don't have to serve that instituting document or documents, because the court then deals with the matter ex parte or without notice and makes an order, unless the court requires you to issue either in the one case a summons or in the other case to serve the arbitration claim form. So we would say it ought to come to the same thing, but I take your lordship's point that there is a difference in the way it's been formulated. Can I go back then to 62.18 in the photocopy? I was just taking your lordships through the remainder of that provision. Subparagraph 5 you're not concerned with because that deals with agreed awards. Subparagraph 6 deals with the evidence that the application for permission must be supported by. And then 7b, and that's an important provision because it's that provision that requires the order that gives permission to be served on the defendant. So 7b is the one that tells you that there is a document that is required to be served, that's the order. Then 8 tells you how service of the order is to be effected out of the jurisdiction. Subparagraph A states that this can be done without permission, so you don't need permission. B states that service can be effected in accordance with rules 6.40 to 6.46, as if the order were an arbitration claim form. In our submission, the order does not thereby become a claim form, but it can be served as if it were one under those rules. And the relevant provision as regards service of the order on a state is 6.44, and I'll come to that. Just before I do so, can I just invite Lordship's attention to paragraph 9, which provides that within 14 days of service or such other period as the court sets, if it's to be served outside the jurisdiction, the defendant may apply to set aside the order, and the order must not be enforced in the meantime. So the court has the ability to set a period of time if the document is being served outside the jurisdiction. If you then have a look at 6.44, which you find somewhere in the middle of this clip, it's page 339 of volume 1. This explains the procedure that applies if the order of the court giving permission to enforce the award is served, and that tells you, is served on a state, and that tells you how you do it, and in particular, what you have to do under subparagraph 3 is file it in the Central Office of the Rules of Courts of Justice and request for service to be arranged by the Foreign and Commonwealth Office and so on. And so that sets out the procedure that will apply. However, as I've already indicated, this rule, 6.44, is obviously subject to the rules in 6.16 and 6.28, which allow for dispensing with service. Now, can I then go back to 62.18 at the back of the clip? To make some submissions about it. Our case is that when an order is made under 62.18 ex parte, there is no document that falls within section 12.1 of the Act. And that is because there's no document that's required to be served for instituting proceedings. The arbitration claim form instituted the proceedings but did not need to be served, whereas the order of the court is required to be served but did not institute the proceedings. And let me expand on that by referring to the 5 steps that we say are involved in the analysis. Step 1, there can be little doubt that the arbitration claim form institutes the proceedings. That is true of all claim forms and is stated in terms in CPR 7.2, which provides that claim forms start proceedings. And in relation to arbitration claim forms, that is in 62.3, and again it provides that arbitration claim forms start proceedings. And indeed the learned judge accepted the proposition that as a matter of English procedural law, the proceedings are instituted by the issue of the arbitration claim form, and he said that in his judgment at paragraph 37, but there's no need to turn it up. So that's step 1. Step 2, there's no doubt that the arbitration claim form need not be served if the matter is being dealt with without notice. Step 3, it follows from step 2 that section 12.1 of the Act does not apply to an arbitration claim form that is not served or required to be served. And that's not challenged by the respondent on this appeal, and it's also confirmed by the decision of Mr. Justice Teare in the Gold Reserve against Venezuela case, which is in Authorities Bundle 2 at tab 19. Step 4, the ex parte order of the court granting permission to enforce the award is required to be served, and your lordships have seen that in 62.18 subparagraph 7b. However, step 5, the ex parte order of the court is not required to be served for instituting proceedings, and that's because the proceedings have already been instituted by the issue of the arbitration claim form, and indeed the court has already made a substantive order in those proceedings. And indeed, in the present case, more than a month elapsed between the issue of the arbitration claim form and the making of the enforcement order. The proceedings had been on foot for all of that time, and in those circumstances, the requirement to serve the order could not, we submit, be for the purposes of instituting the proceedings. Now, it was that last step in the analysis that has proved controversial. It was here that the learned judge moved away from the perspective of English procedural law, and he concluded, as I've shown your lordships, that that was not the perspective from which to judge matters under the Act. And for reasons that I've already developed, we submit that the judge went wrong when he departed from the perspective of English procedural law on that point. Now, he cited in particular two authorities on this aspect of the matter. The first is a decision of Mr. Justice Gross in the Norsk Hydro case, and the second is a decision of Mr. Justice Kanan Ramesh in the Singapore High Court in a case called Van Zyl against Lesotho. And I'll just deal with each of those two authorities briefly, if I may. Now, as regards Mr. Justice Gross in the Norsk Hydro case, I don't need to say too much about that because the learned judge rightly recognised that that only provided limited support to his conclusion, and that was because the argument that we're advancing about the nature of the enforcement order was not made to the court. Instead, the only argument that was made to the court in that case and that was rejected was that Section 12 did not apply to the court's enforcement jurisdiction at all. And Mr. Justice Gross said, well, that's not right. I think it applies both to an adjudicative jurisdiction and to an enforcement jurisdiction. But no submissions were made to him along the lines of the argument that I'm now
It just
making.
proceeds on the assumption, doesn't it, really?
Indeed.
The relevant part of the judgment proceeds on the assumption that the order was the
relevant document.
relevant document.
Indeed. And all that he deals with is this question about whether Section 12 has any application to an enforcement jurisdiction, and he says that it does.
And the order had been served through the FCO.
In that case,
Hydro case.
in the Norsk Hydro case, I'd have to check that.
My Lord,
I
that's
think it
correct.
was because I think it. Sorry, Mr. Davis.
I'm just confirming that my
Yes.
Lord is correct.
So it's all arbiter anyway,
Yes, it had been
in
served.
one sense.
My lord is right. Now then, in the Van Zyl against Lesotho case, which is the Singapore case, we accept that does contain a reasoned analysis as to why an enforcement order falls within the Singapore equivalent of Section 12 of the 1978 Act. However, there are important points of distinction between the procedural position in England and the procedural position in Singapore. In England, it is clear that proceedings are instituted by the issue of claim forms. And that's stated in terms, as I've said, in CPR 7.2 for ordinary claim forms and CPR 62.3 for arbitration claim forms.
What was the two references again, please?
I'm sorry, my lord. 7.2
Yes,
for ordinary claim forms,
yes,
62.3 for arbitration claim forms.
thank you.
But there do not appear to be equivalent provisions in Singapore from what we can tell looking closely at the judgment. There is also no equivalent in Singapore of 62.188b insofar as that rule incorporates by reference Rule 6.44 concerning service on a state. So you don't have the equivalent of what we have, which is 62.188b, incorporating by reference 6.44 in relation to service on a state.
Why does that make any difference?
Well, it could make a difference in the sense that if you do have to serve the order, And 6.44 tells you this is how you can serve it on a state, but is then subject to the powers of the court to dispense. In Singapore, you're left in this rather odd situation where, because you're not told specifically that the equivalent of 6.44 applies, you're actually left not knowing how to serve the order, and therefore it could be argued that in that case you needed to refer to the primary legislation to be told how to do it. Perhaps more importantly, anyway, the decision we submit of the Singapore High Court really does suffer from the same problem as the decision of the learned judge below, which is that it's impossible to see on the wording of the statute how the enforcement order can come within the words of the statute when it is not a document required to be served for instituting proceedings. And in truth, the learned judge reached the conclusion that he did as regards the enforcement order because he considered, as I've said, there would always have to be a document falling within section 12, and we say that that conclusion was wrong on the plain language of the section and in the light of its purpose to restrict the scope of state immunity.
Can I bear with me for a moment? Are you going to come back to the RSC or not? Because if you're not, I've got a question to ask. I've been speaking, I've been looking at this.
I wasn't planning to, my lord.
The primary submission, of course, is that archaeology is irrelevant.
That is
It's
my
a referential statute.
that
But
is my
if it
position.
isn't, and we reject that, then we do want to know about RSC 7.
But can I take you back to the revision again?
My lord, yes, of
You gave
course.
us in tab 7. Now, when do you say under this rule the enforcement proceedings began? Because no summons, on this hypothesis, no summons has been issued, the court hasn't directed it, and all you've got is an affidavit which asks the court for permission for leave to enforce. So when do you say the actual enforcement proceedings begin?
Well, it looks like you have to, the affidavit supports an application, and so at the moment that you,
It's an application for leave.
an application for leave,
Contemplate a written document applying for leave.
indeed, and
Yeah.
at the moment that you issue that application and then present it to, I would say at the moment of issue of the application, the proceedings are instituted, just as they are at the moment of issue of an arbitration claim form. They are instituted. But at the moment of issuing the application for leave, they are instituted. You then go along to the court ex parte with your application and your affidavit. The proceedings must have been instituted because the court is already moved to hear the case, and indeed.
You're only asking for leave, so I was making an analogy, it may be a bad analogy, so I'm just putting it through. When you apply for permission to bring judicial review proceedings, so far as the defendant is concerned, the application for permission itself isn't the originating process, is it? It's the actual claim form, I assume, in the judicial review. And I'm trying to see if there's an analogy here.
Well, I think the difference here is that the application for leave will actually result in the substantive relief that you're seeking. You actually get leave to enforce the arbitration award as if it were a judgment of the court. All of that happens ex parte. And indeed, if it's never set aside by application by the defendant, then that is it. That's the substantive relief that you've asked the court to make, and the court has made it on your application ex parte.
True, but I mean, I'm just acting as a devil's advocate here, and I'm trying to think about the Singapore judgment, and I'm trying to think about the policy considerations on that Lord Justice Mayles was raising in his judgment. It might be said that so far as the defendant is concerned, under the original way this was set out, where you didn't have to issue an originating summons, that so far as the defendant is concerned, it is in fact service of the order, which is required, and the only thing that's required there. It might be said that in one sense that is the real process as between the claimant and the defendant.
Well, with respect,
It's more difficult, I agree. On the present form, I can see exactly where you're coming from.
Well, yes.
But I'm trying to put myself in the position of the drafters of the legislation, what they would have regarded.
And one of the oddities is, really following up what my lord has said, one of the oddities of 7510 is that you didn't have to issue an originating summons unless the court ordered you to.
Yes.
But if the court did order you to, then no appearance had to be entered, and there's no reference anywhere to it having to be served.
But you'd have, I think you would have to serve it unless there was some dispensing. I mean, it's one thing you don't enter an appearance, but
Yeah.
there's no dispensation with service, so I'm not sure.
Well, that may
that's
be right.
obvious.
That may be. I think one would need to
They're
look at
different. They're different points.
the archaeology a bit more closely, really. But my lord's real point was where you don't have an originating summons, there's nothing obvious that's initiating the proceedings.
It's just a
the
thought. That was
application.
all I wanted
No, I
to
see
put out
that.
in your mind. That was all. I
Well-
totally take your point. I'm not querying, certainly at the moment myself, your analysis of the current rules. But I'm trying, I think what we have to do is to try to put ourselves, to some extent, into the position of the drafters and what were they thinking about?
Well, can I make a couple of observations, my lord? Well, first of all, my answer would be that the proceedings, even under Order 73, Rule 10, must have been instituted at an earlier point, because it's very difficult to see how you can have a situation where the court is granting the substantive relief sought in the action, and yet at one and the same time be contending that the proceedings haven't even been instituted yet. That substantive relief is made against the defendant, albeit that the defendant then has the right to set it aside. That's one point. The other point I want to make is this. Of course, I understand entirely why your lordship is concerned to understand the history here, and indeed that's why we have put before the court the original Order 73, Rule 10, and so on, in order to explain that. What I don't want to do is to go too far in this regard, and that's because it's difficult to know what Parliament did or didn't have in its mind in 1978. As I say, in fact, the Act, the 1978 Act, had been granted royal assent 4 days before this provision came out. And so, even though the Act actually didn't commence until 3 months thereafter, and so you could argue that actually one shouldn't go too far down the road of looking to see what Parliament might have thought about this provision, because actually this provision came 4 days after royal assent had already been granted in relation to the Act. And that's why we submit that rather than the court being overly troubled by the precise procedure as it existed in 1978, that's very unlikely to have been Parliament's intent. What it was much more likely to have intended was that one has to look, because you're looking at the procedural law, and one knows that the procedural law changes every year with a new white book and so on, one has to look at the development of what the Parliament expected the rules of court to change over time.
Yes, thank you.
So you say that if we go into this archaeology, we shouldn't really even be looking at 73 Rule 10, we should be looking at the state of the law before 73 Rule 10 was enacted.
Or, that's one possibility. Or, another possibility is that because the timing was so close in time, that this would be a relevant document to look at. I mean, by way of example, I think we said in our skeleton that the Lord Chancellor at the time was both the sponsor of the Act through Parliament and also the head of the Rules Committee at the time. So you could make the argument that it's very unlikely that Parliament was not aware that this rule was coming out 4 days later. But it's a difficult one because of the timing is obviously very, very close indeed.
No one is inviting us to go into archaeology before Order 73
Well,
Rule 10.
that's largely true, although in submissions that I'm about to come to, there's a little bit of that.
There must have been some provision in the rules of court in the RSC prior to 7310 in relation to enforcement of arbitration awards under Section 26 of the 1950 Arbitration Act. And the explanatory notes seem to suggest that the 7310 was introduced in order, really, so you could start you could make your application for leave by affidavit rather than by originating summons, which suggests that the previous provision may have been that you had to issue an
Summons.
originating summons.
So I don't, I'm afraid on my feet I don't know the answer to what was there even before. In
This
relation,
could help you, see.
it might do.
It could
Um,
help you.
We might need to
You
look
don't
at...
quite know because you're digging the site. You're not quite sure what's there, but I think it is quite a useful exercise to do because, I mean, you do make just now quite an important point, which is that that we must assume that they would have known that the rule was coming into effect within a few days, and if you are right in saying that the procedure under this 73 Rule 10 was commencement by an affidavit without requiring the service of a summons, that supports your case. But I mean, it would be interesting to know, and that would be particularly true if, as my lords indicated, actually before this came in, you did have to serve a summons.
so
We need to
So
look
it
at
would
the
be quite useful
1978
to know, I think.
we
We
will,
need to look at the 1978 White Book, because that would have been the one that was applicable when the State Immunity Act was passed.
well, like my lord, the Master of Laws, I only have the 1999 White Book.
Yes,
but
I only have 1999
we will,
as well.
we will try to
And-
ascertain
and-
the answer to that.
Well, it
They
used
are,
to
they are all kept somewhere, I can't
Well,
remember.
there used to
They
be
are.
at the top of the Inner Temple Library, but of course that's no longer there.
I'm sure Lincoln's didn't have them, I'm sure.
Lincoln's will have them, I'm sure.
Anyway,
So we-
I'm sorry.
We will try to find
I think it's just useful. I mean, it may be a small part of the overall.
No, no,
argument,
not
I
at all.
understand, but it would be useful just to cross that T.
My lord, yes. Just to finish on 62.18, we do say that there, and I think I've made to some extent this point already, that there are strong policy reasons to ensure speedy and efficient enforcement of arbitral awards, and those policy reasons make it entirely sensible that if enforcement is dealt with ex parte, then no document will fall within Section 12. And if that happens, all you have to do is serve the order under 62.18 7b. You're told that under 62.18 8b that 6.44 applies, but of course you can dispense with service as well if you need to. Now, that's what I wanted to say about 62.18. Can I move on to deal with some other matters that were relied on by the learned judge? And this is really the last part of the matters that I wanted to address in my submissions. First of all, the judge gave considerable importance to the fact, and this is really linked in with the point we've just been discussing. He gave considerable importance to the fact that as at 1978, there was no general power to dispense with service of originating process. Now, for reasons I've already submitted, we say that doesn't matter because you're not fixed in 1978. That's because of the way that Parliament is legislated. But what your Lordship should understand anyway is that even in 1978, it was the case that some proceedings could be instituted without a requirement for service of originating process. Now, in the RSC, and I'm now not talking specifically about enforcement of arbitration awards, I'm just talking generally. So in the RSC Order 7, Rule 7, that provided for ex parte originating summonses, and indeed that's reflected in the judgment of Mr. Justice Peter Gibson in the Westminster City Council case that I've already referred to. Now, he didn't consider that an ex parte originating summons was appropriate in the specific case that he was dealing with. But it is clear, we say from his judgment, that had he thought the procedure was appropriate, it would have provided an answer to Section 12. And of course, that was already in force in the rules in 1978. And in addition, also in 1978, in the Rules of Court, there were procedures similar to those that now apply to the enforcement of arbitration awards. And we deal with this in our skeleton argument at paragraph 23. But in particular, registration of foreign judgments under the 1920 and 1933 Acts was achieved by obtaining an order for recognition ex parte and then providing the defendant with an opportunity to set aside the order. And such cases did not, therefore, involve a requirement for the service of the document that instituted proceedings. And So that is an example, not in the arbitration context, but in relation to the enforcement of foreign judgments. It's an example of a process similar to the process that applies for enforcement of arbitral awards that was already in the rules in 1978. Now, I should point out that later authorities have made it clear that prior to 1978, it would have been very difficult to seek registration of a foreign judgment under either of those two acts against a state. And there are no reported cases of that having been done against a state. And that's because prior to the 1978 Act, absolute state immunity would have prevented such registration. But the point still stands that Parliament would have been aware in 1978 that procedures did exist where originating process was not required to be served, even if a general power of dispensation did not then exist.
And indeed, insofar as it's helpful to really contemplate Parliament's intention at all, which we obviously must do, they will be far more familiar with foreign judgments, which had been registrable since 1920 and 1933 over a long period of parliamentary history, than they would be with arbitration awards.
My Lord, yes.
So can we just relate that point back to the Act? Now there are various because Section 12 is not limited to arbitration awards. It's a general provision.
General provision.
And you're saying that that in 1978 there were procedures which could involve a foreign state, other than arbitration proceedings, where you could commence your enforcement proceedings without having to serve an originating process.
That's
So can you just...
Although I was forgive me, my Lord, I was making it clear that that there are no reported cases where that had actually been used, those acts has been used against a state, and that's because absolute immunity existed.
I understand that, but again, it's all part of this architecture, right? So what you told us, what you said to us was, from Section 2 to Section 11, there are a whole series of exceptions from immunity. So what I'm asking you is whether, leave aside the arbitration exemption or carving out, there are other provisions here to which it's clear that the ex parte or non-originating process proceedings for enforcing a foreign judgment could have applied against a foreign state, to which Section 12 would apply. So it's not the arbitral context.
Well, Section 3 is the obvious example, isn't it? Commercial transactions and contracts to be performed in the United Kingdom.
Absolutely. There are, I'm not...
So, I mean, that picks up on the Trentex point, doesn't it?
Indeed.
So I mean, again, I'm trying to say this seems to be a point in your favour, but I don't want to make a false point. So what I'm trying to say is, so you could have, leave aside arbitration, but you could have a commercial transaction and contract recognised as accepted from state immunity under the 1978 Act. Doesn't involve arbitrations, but where it is clear, you're saying, that Parliament would have been aware that the enforcement of a judgment obtained abroad in relation to that could have been effected without having to serve an originating process.
Well,
Is that right or wrong?
that's it's a little bit more complicated, and that's because what you have in the State Immunity Act are these various exceptions, and my Lord Justice Flaux is right to say that one of the key exceptions is the commercial transactions exception in Section 3. What you didn't have in the 1978 Act was a specific exception for the recognition and enforcement of foreign judgments. So there isn't a specific exception for that. And in fact, that didn't come in until sometime after, because it came in as Section 31 of the Civil Jurisdiction and Judgments Act 1982. And that...
1982.
CJJA 1982, Section 31, that is headed Overseas Judgments Against States, and it makes it clear that a judgment given by a court in an overseas country against a state shall be recognised and enforced in the United Kingdom if two conditions are satisfied. One, that it would be so recognised and enforced if it had not been given against a state. So, in other words, it would be generally recognised and enforced. And two, that the court would have had jurisdiction in the matter if the foreign court had applied rules corresponding to those rules under sections 2 to 11 of the State Immunity Act. So it's not until 1982 that a specific provision dealing with overseas judgments against states is actually introduced by primary legislation. You don't have an exception in the State Immunity Act itself that deals with that.
So I'm sure you would have prepared all of this as part of your deal of submission. So it sounds as though you haven't been able to find a case where under the exceptions in sections 2 to 11, in 1978, section 12 could have applied where it wasn't necessary to institute proceedings. Could be done ex parte, other than arbitration, which you dealt with.
Well, that's subject to the point I just made, which is that there was already a general power of ex parte originating summonses. So Order 7, Rule 7, provided for ex parte originating summonses. So there was, I'm not suggesting that's specific to proceedings against a state, but there was a general power in the court for some types of proceedings, not all, but some types of proceedings to be begun ex parte by originating summons.
And could any of those have, that's the same point I'm making again, and can you relate that to any of the 2 to 11 exemptions? We haven't gone back to that general power.
I don't think I can do that specifically. I think our point is a more general point, which is that Parliament would have been aware in 1978 that in English procedural law, there are procedures that already existed where originating process did not need to be served. I'm not suggesting.
Just back to your point that if what Parliament has intended this section to mean is what the judges held it to mean, and what Mr. Davis argues for, which is that it's a mandatory provision requiring proceedings to be instituted and served on the state, Parliament would have said so.
Parliament would have said so. That's exactly right.
Precisely because Parliament's taken to have been aware of the fact that there were, albeit in a relatively narrow compass, there were circumstances in which you could initiate proceedings in England without serving the proceedings on the other party.
Indeed, and Parliament would be taken to be aware that procedural law changes and develops, and that other procedures of a similar kind, or going beyond that, might be introduced in due course. And Parliament doesn't say, the one thing it doesn't say is that in every case where there are to be proceedings against the state, a document must be served. It doesn't say that. And therefore, had that been the intention of Parliament, we say that the provision would have been drafted totally differently. Now,
sorry, Mr. Toledano,
Not at all.
I don't want to barrage you with archaeological questions, but you referred us to section 31, I think, of the CJJA.
yes.
Is there any indication as to why that was suddenly introduced in 1982? Had there been some case where the point had come up? Or?
If you give me a moment. We'll have to, again, I don't know the answer to that, I'm afraid. We'll have to find out.
It may just have been a loose end that wasn't covered by the State Immunity Act, I suppose.
My lord, yes. Can I then move on to a separate matter relied on by the judge that I need to deal with, which is the European Convention on State Immunity, 1972. Again, this was something that the learned judge thought significant. Can I invite your lordship's attention to that? That's in Authorities Bundle 1 at tab 2. And the relevant provision is set out at the second page of the extract, which is Article 16. And in particular, your lordships will see in paragraph 2 that the convention provided that the competent authorities of the state of the forum shall transmit the original or a copy of the document by which the proceedings are instituted, a copy of any judgment given by default against a state which was defendant, through the diplomatic channel to the Ministry of Foreign Affairs of the defendant state for onward transmission, where appropriate to the competent authority. The judge considered that it was evident that Article 16 contemplated that in every case there will be a document by which proceedings are instituted, and that this document must be transmitted through the diplomatic channel. The judge then said that he thought that was carried through into Section 12 of the Act. Now, in our submission, the judge was wrong to place reliance on the Convention. The Act did not purport to mirror the Convention and departed from it in several ways. First of all, the Act applied to all states and not just to those that were signatories to the Convention, and aspects of the Act differed from the Convention. And by way of example, Article 12 of the Convention, dealing with arbitration, did not extend to enforcements of awards, whereas, as I've said, Section 9 of the Act was deliberately extended to cover enforcement. And most significantly, we submit, the parliamentary draftsperson did not adopt the language of Article 16 when drafting Section 12. New language was drafted requiring, as we've seen, the diplomatic channel to be used only for documents required to be served for instituting proceedings. And we submitted that in the light of such a clear and marked change of language, it simply cannot be assumed that Parliament intended to convey the same meaning as the Convention. Indeed, the differences between the Convention and the Act are so pronounced that the Supreme Court practice stated in its 1999 edition that it was doubtful whether it would be at all helpful or proper to refer to the Convention in aid of the interpretation of the Act. And there's no need to turn that up now, but the extract from that 1999 work is in Authorities Bundle 2 at tab 29. And I would add also that in his judgment at paragraph 40, the judge said that he did not consider that the Convention was concerned with the niceties of English procedural law. Now, in fact, as we point out in our skeleton argument, the explanatory report to the Convention states in paragraph 60 that the procedural concepts referred to in Article 16, in particular, quote, the document by which the proceedings are instituted and, quote, judgment by default, are to be given the meaning that they have in the lex fori, because it was not possible to reach unification of practice or even common definitions. And again, there's no need to turn it up, but the explanatory report is in Authorities Bundle 2 at tab 34. So contrary to what the judge said, even under the Convention, regard was intended to be had to the niceties of the procedural law of the lex fori, in this case England. That's the Convention. The next matter relied on by the learned judge were the particular sensitivities involved in proceedings against a state, as regards which he considered that a careful balance had been struck in the Act. And he thought that it was significant that Section 12.1 of the Act gave the Foreign and Commonwealth Office a role, because this would allow it to decide whether, and if so when, to serve the proceedings. And this meant that the FCO could, for example, delay service at sensitive times, such as when there was an election pending in the foreign state. Now, the judge was concerned that if you dispense with service, you would render such a safeguard illusory. And that was said to be one reason why, on our construction, the operation of the section would give rise to what he called grave difficulties. Now, if we're right about the meaning of the section, then Parliament has seen fit not to impose the FCO safeguard in every case. And I can just invite your Lordship's attention to paragraph 20, on this point, paragraph 29 of the judgment of the learned judge, which is in tab 8 of the core bundle, at page 96. this is where the learned judge dealt with this point about the sensitivities and the FCO. And if your lordships look in line 5 of paragraph 29 at page 96, what he said was that section 12 contemplates that no state will be brought before the English courts except as a result of service in accordance with section 12. And we say that there is an element again here of circularity in the analysis. It assumes the answer the judge wishes to extract from the point. To state the test as the judge does, as being that no state will be brought before the English court except in the way identified, it is, we submit, to effect a major reformulation of what the statute actually says. And on any view, his formulation goes too far, because we know from other parts of section 12 that Parliament didn't consider that the FCO would always have a role to play. And I think I already referred to the fact that actions in rem, by way of example, are specifically excluded by section 12.7. Those actions can be progressed without FCO involvement, presumably by simply affixing the court order to the vessel, as is standard practice in such actions.
Well, it was standard practice. It probably was standard practice in 1978.
My lord, yes. So certainly, those don't. Section 12 does not apply to actions in rem. They are carved out. Clearly, Parliament didn't think that you always had to have the FCO involvement. And similarly, section 16 of the Act contains a number of types of proceedings that are excluded from the Act, and they're set out in section 16. And again, they indicate that that the FCO involvement was not considered by Parliament to be essential in all cases. Now, on our case, the safeguard referred to by the judge would not be illusory. It would simply not apply where documents were not required to be served for instituting proceedings. And that would cover the two categories of case that I've already referred to, where it's not required by the default rules or where service has been dispensed with. And it goes without saying that the court would not always be willing to dispense with service and would not do so lightly, especially as against a state. It would only do so if it considered it appropriate to do so, and under CPR 6.16, if that's the provision that applies, then it would only do so in exceptional circumstances. Most likely, the court would require as a minimum that steps were taken to bring the proceedings to the attention of the state, thereby mitigating any perceived concern about safeguarding its position. And your lordships will have seen that in the present case, Mr. Justice Teare required my client to undertake to courier documents to 3 addresses in Libya, so as to, or I think 2 in Libya, 1 was elsewhere, so as to ensure that the proceedings came to the attention of the state, which obviously they have done. So far as the enforcement of arbitral awards is concerned, we say that Parliament can be taken not to have required the same FCO safeguard as might exist in ordinary cases because of the policy consideration about the enforcement or speedy enforcement of arbitral awards. So that's that particular matter. And the next matter I wanted to deal with was the other subsections of section 12, because the learned judge said that these were of some importance, and it would be helpful therefore if you could go back to the Act itself for the purposes of these submissions. And I think I've already said that what you have in the other subsections is you have section 12.2, which provides the time for entering an appearance shall begin to run 2 months after the date on which the document is received as aforesaid. And then in 12.4 and 12.5, you have additional protections as regards obtaining a judgment in default. So to respond to what the judge said about these different subsections, I need to deal separately and in a little more detail with the 2 categories of case that the court is concerned with. First, dispensing with service generally, and secondly, the enforcement of arbitral awards under 62.18. So far as the first category of case is concerned, where the court dispenses with service, our response in relation to the application of sections 12.2 to 12.5 is that they will not be engaged because no document will have been served under section 12.1. In the absence of service of a document under section 12.1, there will be no acknowledgement of service and therefore no room for the application of sections 12.2 and 12.3. Similarly, in the absence of any requirement for an acknowledgement of service, there will be no scope for default judgment, which by definition, now contained in CPR Part 12, requires there to have been a default in the filing of an acknowledgement of service or a default in the filing of a defence following the filing of an acknowledgement of service. It follows, we submit, that there will be no room for the application of sections 12.4 and 12.5.
It must be the case, mustn't it? Because in the case of an arbitration award, where you get an order to enforce it as a judgment of the English court, by definition, the judgment you got is not a default judgment.
Well, and I'm coming to
It can't be saying any default by the state is only in relation to the non-payment of the award. It's not.
Well,
It's not some failure in relation to the procedural rules.
So, my lord, we entirely agree with that, and we submit that is absolutely right. The learned judge, and I'm coming on to this, thought that the position was otherwise. He thought that the order of Mr. Justice Teare made ex parte in this case did actually contain a default judgment element, or would contain a default judgment element if the state decided not to apply to set aside. And we say that's wrong because for exactly the reason that your lordship gives. But I'll come to that.
Okay.
But instead of default judgment against the state, which doesn't participate and where service has been dispensed with, it will therefore be necessary to obtain summary judgment under Part 24 with the permission of the court, or to follow the procedure in CPR 39.3, which concerns an uncontested trial. So you won't be able to go for default judgment because you've dispensed with service, there's no acknowledgement and so on. And instead you have other routes available to you in order to take the matter forward. This is
Summary judgment, don't you have to have an acknowledgement of service?
My lord, your lordship is right. Although with the permission of the court, you can go for summary judgment even without an acknowledgement of service. So that's in Part 24. Your lordship is absolutely right that the standard position is yes, you need an acknowledgement of service. There is a provision that says, but if you haven't got acknowledged service, with the permission of the court, you can go for summary judgment.
It's a procedure that's adopted reasonably frequently in the commercial court if what you want is a reasoned judgment.
Yes, exactly.
As opposed to just a piece of paper that's a judgment in default.
That's exactly right, my lord. And another way of doing that would be to go under 39.3, which is this uncontested trial. And indeed, in the EU Syria case, which is one of the cases in the authorities before the court today, summary judgment was exactly the route that the claimant chose with the permission of the court. That was a decision of Mr. Justice Bryan. No need to go to it, but it's in Authorities Bundle 2, tab 21. In that case, the EU had managed to serve Syria in accordance with section 12.1, but had received no acknowledgement of service. The judge granted permission for the EU to proceed by way of summary judgment, in particular, because the judgment will be easier to enforce in other jurisdictions. Now, of course, if we're right and steps 12.2 to 12.5 are not applicable, then it's correct, as the judge said, that the state won't have the protections identified in those subsections. But the Act doesn't say that those steps must always be applicable, only that if they apply, then the protections must apply too. What is more, even in a case where the court has dispensed with service, the court can, if it so wishes, grant additional time to the state in which to deal with any step that the proceedings involve, and thereby ensure that the state has every opportunity to participate. So that's our answer as regards sections 12.2 to 12.5, where the court has generally dispensed with service. The position of enforcement of arbitral awards is a special one because, again, it requires regard to be had to 62.18 to see whether 12.2 to 12.5 have any application. And in our submission, those subsections of the Act simply have no application where an order for permission to enforce an award is made ex parte under 62.18 and the defendant then has an opportunity to apply to set aside the order. And that's because in that situation too, there is no acknowledgement of service and there is no possibility of default judgment. The procedure we submit is sui generis and entirely different. Now, as I've said, the learned judge seemed to think that the order of the court under CPR 62.18 was a default judgment or would become one if no application was made to set it aside. He thought that was so because the order not only granted permission to enforce the award, but also entered judgment in terms of the award. And he therefore said, well, therefore you've got an entry of judgment as such. However, what he didn't take on board is that the entry of that judgment is not the entry of a default judgment. Default judgment only arises, as we know from Part 12 of the CPR, in the circumstances I've identified, where you don't put in acknowledgement of service, or you do, but you don't follow it up with a defence. Now, under the 62.18, when judgment is entered, there's been no antecedent requirement for filing an acknowledgement of service or for filing a defence. There's no default of any kind by the state at the point that the judgment is entered. The state has the right to do something at a later stage, namely to apply to set aside the order and the judgment if it so wishes. If it does do so, the application to set aside is exactly that. It's an application to set aside. It's not an acknowledgement of service or the equivalent thereof. And if the state does not apply to set aside, that does not turn the judgment that was not previously a default judgment into a default judgment. Now, those questions have been considered by Mr. Justice Stanley Burnton, as he was then, in a 2003 case called AIC Limited against Nigeria. Lord Justice Mells was not shown that decision because, as your lordships know, Libya was not then contending that the court did not have a power to dispense with service. That was not a point they took below, and so the issue hadn't arisen. But I want to show your lordships the point in Mr. Justice Stanley Burnton's judgment so that you can see it. Can I ask you to take up Authorities Bundle 1 at tab 14? Now, I should say straight away, this is not an arbitration case. This concerned enforcement of a foreign judgment under a procedure that was materially identical to that which applies when enforcing an arbitral award. And in our submission, precisely the same reasoning should therefore apply to the enforcement of an arbitral award. And I just want to show your lordships one paragraph, which is 23. And first of all, the learned judge referred to some assumptions that were being made by those acting for AIC. And then if you look in the middle of the paragraph, he says, in my judgment, those assumptions are unfounded. An application to set aside the registration of a judgment is not a corresponding procedure to an entry of an appearance. An entry of an appearance is an act that precedes a judgment, whereas an application to set aside a registration is made after judgment has been entered into. The registration of a foreign judgment is not the equivalent of a judgment in default of appearance. It precedes the service of any UK proceedings on the defendant. Section 12.4 and 12.5 of the 1978 Act, that is, cannot be made to apply to the registration of a judgment under the 1920 Act on an application made without notice to the defendant state. So I'll come back to the last sentence in a moment. So he very clearly held in that case that an application to set aside was not an entry of appearance or a procedure corresponding to an entry of appearance, so it didn't fall within 12.2 of the Act. And he also held that an order enforcing a foreign judgment was not a default judgment. Essentially, the process is entirely different. There's no default on the part of the defendant's state, which was the point that my Lord Justice Flaux made. We say that Mr. Justice Stanley Burnton was right on these points and that the learned judge below was wrong to the extent that he thought otherwise without the benefit of seeing this analysis.
How did this point rise in that case? He talks about the claimants having made some assumption which he then says is wrong.
Yes.
What was the assumption that the claimants made?
Well, you can see that he describes them at the beginning. He says they have assumed that the service of a notice of an order of registration is the equivalent of a writ and therefore falls within 12.1.
So they did serve through the Foreign and Commonwealth Office.
I think that's right.
It may help, because I was going to come to this decision. It's at paragraph 8 of the judgment. They did serve the order in accordance with the FCO requirement under section 12.2. That was the 12.1, I beg your pardon. That was the assumption that they made as being correct. As we see in many cases, that is the assumption that is made. And that's what Mr. Justice Stanley Burnton was dealing with obiter at 23, because of course he's already held, well, this is all immune anyway, because...
What I'm trying to get at is, why did the judge feel it necessary to say that this assumption was wrong?
I don't know, my lord, is the answer to that question.
I mean, why?
You're right, of course, but I'm slightly puzzled as to why it really
Why he
works.
goes into this? I mean, I think I'd accept he didn't need to make these observations in view of what he decided in the case, on the case. But nonetheless, they are important observations. We say they're correct, and in particular, as regards whether or not the order it constitutes a default judgment, which we say plainly it doesn't, because there's been no default on the part of the state. Now, I should point out that, for completeness, that in the Norsk Hydro case, Mr. Justice Gross stated obiter in that judgment that an application to set aside an order for enforcement did fall within the words entering an appearance in section 12.2 of the Act. But he didn't give any reasons for that conclusion, and it doesn't appear that he was told about this decision of Mr. Justice Stanley Burnton.
Well, it would have been quite difficult for him to be told about the decision, because it was actually decided 8 months later. Because Mr. Justice Gross's decision, although reported in 2009, is actually the 18th of October 2002, whereas Mr. Justice Stanley Burnton is the 13th of June 2003.
Your Lordship,
So
So the question is, why didn't Mr. Justice Stanley Burnton refer to Mr. Justice Gross's?
Yes,
my Lord, forgive me, I misspoke.
it wasn't referred to it.
I was thrown by the... your Lordship is absolutely right. I was thrown by the 2009 citation, but your Lordship is right.
Yeah.
But be
I'm
that,
sure we're going to get much help out of
At least
that.
one of us is on the ball, though.
be that as it may, what matters is what is the correct analysis. And I think your Lordships understand. We say the correct analysis is actually clear. You can't have, where you've got this procedure under 62.18, you don't have the entry of an appearance because it's been dealt with ex parte. You don't have a default judgment, and therefore we say that's the position. I could just show your Lordships what Mr. Justice Teare, just to finish up, if you look at the last sentence of 23 of Mr. Justice Stanley Burnton's judgment, he went on to say, an application for the registration of a judgment under the 1920 Act must be made by the issue and service of a claim form. And that's hard to follow, because that wasn't what was envisaged by the applicable rules of court for the recognition of foreign judgments contained in Part 74 of the CPR. And I just want to show you, just for completeness, because it may be important, what Mr. Justice Teare said about this. That's in Volume 2 of the Authorities, in the Gold Reserve case, which is at tab 19. And if you would be kind enough to look at paragraph 61, which is at page 2847. As you can see from paragraph 61, Mr. Justice Teare was taken to the AIC Nigeria case and the remarks of Mr. Justice Stanley Burnton. And then if you look over at paragraph 64, he said he didn't agree, the bit that he's not agreeing with is that final sentence that I showed you in paragraph 23 that said that you have to issue and serve a claim form. That's the bit that Mr. Justice Teare disagreed with in 64. But I wanted to show you this paragraph because it's helpful to see what he says. He says in
Paragraph you were showing?
64. In the second sentence, he says, in my judgment, Section 12 makes special provision with regard to the questions of service, entry of appearance, and judgments in default of appearance. If the particular proceedings do not involve any one of those steps, then the special provision of section 12 relating to that step does not apply. This appears to me to be clearly so with regard to 12.1. It only applies to writs or other documents required to be served. If the document instituting the proceedings is not required to be served, then the subsection has no application. If an entry of appearance, now acknowledgement of service, is required, then subsections 2 and 3 apply. If an entry of appearance, now acknowledgement of service, is not required, then the subsections do not apply. If judgment in default of appearance, now acknowledgement of service, is sought, then subsections 4 and 5 apply, but if it's not sought, then they do not apply. What he effectively said was that he had no difficulty accepting that some or even all parts of section 12 might not apply, depending on the particular procedure and circumstances of the case. And we say that your lordships ought to adopt that approach in the present case too.
Well, 66 is the critical point, isn't it, because he says, I remain of the view that section 12.1 does not require the service of an arbitration claim form on Venezuela in the manner they're set up, because CPR 6218 doesn't
Indeed.
require it, unless the court orders the contrary.
My lord, yes.
Now, is this the only decision at first instance in which this point has been addressed in an inter-parties argument?
When you say this point, which point?
Your point under section 12.
We've got the 2 points under section 12, the dispensing with service point and the 62.18 point.
Yes.
The dispensing with service point has been considered, I think, once by Andrew Henshaw QC sitting as a deputy, which is the case I mentioned, twice by Mr. Justice Teare, and they have all said you can dispense with service, and then Lord Justice Mells said you can't. In relation to 62.18, it's clear from this case, Gold Reserve, that the arbitration claim form doesn't fall within 12.1. That's a decision of Mr. Justice Teare, but that's not attacked by the respondent in this case. The issue of whether the order has to be served under section 12.1, I think that is not the subject of anything other than the remarks in Norsk Hydro, which, as I said, provide limited support only because the argument wasn't made. That's the Mr. Justice Gross case.
Was that an inter-parties case?
And the Singapore case.
Yeah.
Yes, it was.
Going back to my Lord's point, and the answer to my Lord's question, so far as dispensing with service is concerned, am I not right that all the cases, the decision of Mr. Henshaw and the two decisions of Mr. Justice Teare are all ex parte?
Yes.
I mean, they're all decisions where the defendants weren't represented.
That's true.
Because one of them is his decision in this case.
Absolutely. That's your lordship is quite right. Although it's fair to say that, for example, in the case that Mr. Andrew Henshaw, Queen's Counsel, was dealing with, he was alerted to the possible inconsistency with section 12.1 of dispensing with service. He said there is no inconsistency because if you dispense, it's not required to be served, and therefore there's no inconsistency. So the point.
Just show us that.
He was alive to the point, but it's right. It was the defendant wasn't there. So that, my lord, is at tab 24 of Authorities Bundle 2, and.
This is an ex parte application, or at least the defendants weren't there.
It's 24. Yes, my lord, that's right. Page 11, paragraph 24.
So which tab are we in now?
Tab 24.
Tab 24, paragraph 24. And the relevant paragraphs are really 24 and 25. And in particular 25, which contains the reasoning that I just identified about there being no inconsistency. So certainly he was alive to the point, or the possible point that could be taken, but he didn't see that there would be any inconsistency. And that was essentially followed by Mr. Justice Teare in the two cases that he dealt with, where he also said that there was a power to dispense.
So Mr. Justice Teare in the Gold Reserve had the Henshaw decision in front of him, did he?
In gold, Yeah, Gold Reserve was not one of the... Sorry, Gold Reserve was dealing with the other point, not dealing with dispensing with service generally, or those powers. Gold Reserve was simply dealing with the question of whether, under the default rules 62.18, the arbitration claim form needed to be served, fell within 12.1, and because it required to be served, held no, it didn't. The two cases of Mr. Justice Teare on the dispensing with service point, one is the present case when it came before the court ex parte, and the other is in the bundle at tab 22, and that's the Havlish against Iran case that I've mentioned, and he was referred in that case, as you see at paragraph 17, he was referred to the decision of Mr. Andrew Henshaw, Queen's Counsel, and he effectively applied that in order to say that you could
Mr.
dispense with
Henshaw's case, just so we're clear, was a case where what was being sought, it was an action on a judgment of a US district court, which had to be the subject of an action at common law because the United States is not party to any of the conventions which would lead to enforcement under the 1920 Act or the 1933 Act
That's
or the
right.
1982 Act.
That's right.
So that was a case in which the provisions of Section 12 had to be complied with, and the judge goes through in some considerable detail whether they had been complied with and reached the conclusion that they had.
They had,
And then he goes on to say, well, if I were wrong about that, there's an issue as to whether you could dispense with service, given the history of the case, which is fairly complicated, but from which it's fairly clear that Syria was well aware of the judgment.
Indeed, that's exactly right, and that's why the point that we have on 62.18 clearly didn't arise in that case. You did have to serve within 12.1, but and the decision of the judge was first they had managed to serve within 12.1, and secondly, if he was wrong about that and they hadn't, then, as your lordship says, that there was anyway the power to dispense.
Yeah.
And can I just add this, that of course, in these situations, the court, as I think I've already said, is able to build in protections for the state. Your lordship knows that in the present case, Mr. Justice Teare provided that Libya should have 2 months from the date of his order to make an application to set aside. Now, I accept that's not the same as 2 months from the date of service, which is what's set out in section 12, because there was no service which was dispensed with. But what this shows is the court is able to grant additional time if appropriate. Indeed, 62.189 leaves it up to the court to set the period that will apply for setting aside the enforcement order. So the state need not be, and indeed in this case has not been, left in any difficulty. Now, my lords, those are the submissions I wanted to make. I will, if I can, ascertain the position of pre-1978 in relation to enforcement of arbitral awards over the short adjournment. I'll come back to you on that, if I may. I should just add, on the respondent's notice, I wasn't planning to say anything about that now, unless your lordships want me to. As your lordships know, our basic point on that is that it was a discretionary evaluation by the judge and that this court shouldn't interfere, but I can respond to once my learned friend has made his submissions.
Very well, thank you. Yes.
Could I just ask this, which I ought to know the answer to, what was the nature of the proceeding before Mr. Justice Teare in this case? We know it was an ex parte application. Was it all dealt with on the papers, or did he call for a hearing?
There was a hearing in front of him, and indeed in the supplementary bundle.
It's clear from the order, isn't it? There's a point that I was also wondering the same point, that the order makes it clear that there was an ex parte hearing.
Yeah.
Did you represent the...
I didn't.
The leading counsel represented
Yes,
the
the
claimants?
leading counsel did. In fact, we have in this supplementary bundle at tab 1, you have the order of Mr. Justice Teare. At tab 2, you have a short approved ruling, which shows you that
It's Ms. Tolaney.
Ms. Tolaney, Queen's Counsel, appeared on behalf of the claimant at that hearing. So you do have his ruling there. We also have at tab 20 of the supplemental bundle a transcript of the hearing that Ms. Tolaney did in front of the learned judge.
Thank you. For some reason, I don't seem to have anything in my tab 2. I wonder if I could be provided with however short it is, a copy at some convenient moment.
Of course. Shall I hand one up now with that?
Well, do, yeah.
Yes, please.
My lords. My learned friend has probably dealt with there are two main issues really before your lordships that were identified by my learned friend's skeleton, which is, firstly was Mr. Justice Teare's order a document that was required to be served pursuant to section 12.1. Yes. That's the first stage. The second question was, well, if that is right, does this court have power to dispense with service in light of what section 12.1 provides for? My learned friend has amalgamated his submissions, I think, in going through and dealt with both points throughout. I think it might be helpful to take a step back and to take them in turn, which is what I propose to do, to deal with, firstly, is Mr. Justice Teare's order one which was required to be served under section 12 first off, and then I will deal with the issue of the dispensing with the need for service. And a useful start point, I think, is with the first paragraph of the learned judge's decision below. If I could ask you to keep, if possible, open a copy of Lord Justice Mails's judgment at tab 8 of the core bundle. And just to keep in mind what we are dealing with here. And he starts off with the question, can an arbitration award against a state be enforced by court proceedings in this country without service on that state of any formal court document? And that's an important question to bear in mind, because the effect of the appellant's case is that enforcement against the state's assets in this country, if they are right, could be effected without service on the state in question of any formal court document. And that is what underlies in our submission the reason why Lord Justice Mails has come to the conclusion which he has, that this simply cannot be the correct outcome, cannot have been intended by Parliament. And that finds itself reflected in paragraphs 8 and 9 of the learned judge's judgment. In particular, paragraph 9, where he says the effect of this order was that in the absence of any such application within the specified period, the claimant would be entitled to enforce the judgment thus entered against any property of the state of Libya in this jurisdiction, which is for the time being in use or intended for commercial purposes. Now, it may well be the case that Mr. Justice Teare's order had specific provision for I use the word service in
but couriering documents to
documents
known individuals who would enable you to be instructed.
Which was effectively to create an alternative service method. But if they are right on the other side, that order did not have to include that. It could have been just an order for registration of the judgment, and that would be it. They wouldn't have to serve any form of formal document if they are right, that it doesn't fall within section 12.1, because they can dispense with, or the court can dispense with the need for any such service.
Now, as a matter of practice, the court wouldn't dispense entirely in the sense that
no, I fully accept
the court
that.
would always
But
put in
one
something
needs-
like that paragraph.
But generally speaking, one needs to know what ground rules one is
Understand.
applying.
Understand.
And I would submit even more so in the context of a state.
Well, you said it could have just been by registration of what?
But
You did?
they are given leave to enforce the award as if it's a judgment, and then they can, I'm wrong to use the word registration, they can enter the judgment.
Right.
Well, the order of Mr Justice Teare, paragraph 1 I think it is, says that they have permission to, under section 101 of the Arbitration Act, to enforce the award as a judgment. And then a later paragraph actually
Gives judgment.
gives judgment in the same amounts.
Yes, which is under the same act, under the Arbitration Act. If one looks at the order, my
I don't
lord,
think there's any, so that's why I'm saying trouble. I don't think it's a question of registration. I mean, the
Yes.
order itself gave the judgment.
indeed, yes.
But your point is that it is that at least as a matter of strict procedural analysis, if I can put it that way, if you're entitled to dispense with service, then because of the circumstances, then in fact you could have a judgment, the award as a judgment of the English court, which could then be Libya not having made any application to discharge it.
It might not even know about it.
Could be enforced against Libyan property in England.
Indeed, yeah.
And supposing then that some steps were taken to attach Libyan assets, would that attachment process have to be served under section 12?
I suppose it depends on what the nature of the attachment
But there wouldn't be new
process
proceedings,
would
would
be. What-
I don't think there's a new proceeding. It's things like charging orders,
You get
orders for sale,
charging
new
orders,
proceedings,
garnishes.
there's remedies in the course of the proceedings. That would be my initial reaction.
But again, it comes back to the same point, sort of as a matter of practice, any judge or master granting a relevant charging order would be asking what the position was as regards service of the order on the state.
It would, to be fair, as Mr Justice Teare did here.
Yeah.
Although, what is apparent, and I will show you the discussion he had with Ms Delaney on this point, it created an element of doubt. Well, what should I do here? If you're saying if you're saying I can dispense with the need for service, what should I do in terms of the order for making sure that there is some notification to the state of Libya about this? And I'll show you the discussion they had on that at the appropriate time. But what is important also, before Mr Justice Teare, the first point that I'm dealing with was not argued. The issue about whether or not the order needed to be served, well, did the order itself come within section 12.1 of the State Immunity Act? That was not a point that was taken by the appellants. It was assumed that they obviously did have to serve it through section 12.1, which is why they then went on to seek the permission to dispense with service. This argument has only arose shortly before the hearing we had before Lord Justice Mayles. And it's quite interesting that in all of the other cases that one looks at, and I think my Lord Longmore pointed out that in various of the cases, well, the order was served through the FCO. In that instance, that happened in the Gold Reserve case, happened in the Norsk Hydro case, it happened in the AIC case, and it was assumed to be the case in this case until my learned friend, I assume, came across the Gold Reserve case with Mr Justice Teare's suggestion, well, you don't actually tick all the boxes if all you have to serve is the order, not the claim form under 6218. You don't actually bring yourself within section 12.1. So that's, it came upon us sort of late in the day, as it were. It's a clever argument. It's one that deserves respect, but with due respect, it's wrong, we would say, for the reasons that Lord Justice Mayles has adverted.
Well, by the same token, Mr Davis, it might be said against you that before the learned judge, you didn't actually run the point that you couldn't. The court had no power to dispense with service.
Oh, I fully accept that, but I did reserve my
and we
position.
have to decide the issues that are before us.
Yeah. Well, I did reserve that argument in case this matter did come
understand
before
that
your
point.
lordships. And and to be perfectly frank, the reason we didn't run it was because we thought it was so blatantly obvious that if we got over the first hurdle, that this was a case in which the court should not grant dispensation from service, because we were not in the realms of exceptional circumstances. But that's for another argument.
Yeah.
But if I can just highlight, I've got various points.
I'm just trying to understand the point that the very outset of your Justice Mail's judgment, which you refer us, his rhetorical question: can an arbitration order against the state be enforced by court proceedings in this country without service on that state of any form of court document? What actually happened there? I mean, what's happened under his judgment? What has to be served was his order, but his order itself was the enforcement. And it's a slightly odd question in a way, because it wasn't something that could lead to an order for enforcement. The judgment itself both gave leave and enforced the judgment, enforced the award.
It is an enforcement award, order.
Yes.
It enforces the award, but the reason that it's done that way, and it may well be that it goes back to the Order 73 Rule 10 point that your Lordship was discussing with my learned friend, is that when you come to enforce an arbitration award, the process is done generally on an ex parte basis, because the award has been made. The policy is that this country should respect awards and enforce the awards.
Yeah.
So the party is entitled just to go to the court and say, can I please enter judgment on the basis of this award? It's under section 101 to 103 of the Arbitration Act. And that doesn't call for an appearance from the counterparty, whether it be a state or a commercial enterprise or an individual. What it leads to, though, is the granting of the order, which is saying you can have a judgment in the following amount, but you cannot enforce it until a certain amount of notice has been given to the counterparty. That's the process. And the point that we make is that when you transpose that into the realms of a Section 12 situation, it is the order that is calling for an appearance from the counterparty. Again, in this context, the state. It is the...
Well, it's not calling for an appearance, really. But what it's saying is, if you want to challenge this, you've got to do it within 2 months.
Yes, but it's
assumes that having gone through all the process of arbitrating a dispute, that the award will be honoured. Now, in order to honour the award, obviously the other party must be given notice before it's enforceable as a judgment. But it doesn't really require, does it, anything more than having notice of intention to enforce the award?
Well, what it does, if you say you have got a ground to resist enforcement, you will have to come and appear. That's what it's calling for you to do. You have a choice. It's no different to being served with a claim form, in a sense, that I have a claim against you. Here it is. You have 14 days, 28 days in which to respond. If you don't respond, we can take certain steps. It's exactly the same with due respect, my lords. It's not an acknowledgement of service situation, but the
grounds on which you can challenge enforcement of an arbitration award under Section 101 are very, very limited.
Oh, look, they are limited, but
the substantive grounds. I mean, you're here because of the service point, but it's never been suggested your client has some other defence to the award.
Well, my lord, with due respect, we're not at that stage yet.
No, but nobody's put one forward. It's not said, for example, the award was induced by fraud or anything of that kind.
Well, I think it would be wrong for us to do that until we've resolved this particular issue.
Okay.
And I'm not, I'm not going to.
No, I'm making really what was wasn't necessarily tied to the facts of this case. That what the respondent will be doing is seeking to challenge enforcement on one of the extremely narrow grounds under Section 101.
narrow grounds.
And in order to, I mean, to categorise that as in some way acknowledging service or making an appearance seems to me to be inapposite.
Well, with respect, it is what we are given notice that we have X period of time in which to appear and take issue.
Because, I mean, if you, just following the point through, Mr Davis, if you, let's say, forget about the facts of this case, let's assume you had a defence based on fraud or something of that kind, and you come along, and the court then has to decide whether or not to set aside the order and to order some hearing about that. And if it decides that it's not going to do that, then the award will be enforced. But it's not the same as acknowledging service of proceedings, as a consequence of which, unless you successfully challenge the jurisdiction, you'll be taken to have submitted to whatever the jurisdiction is in relation to those proceedings.
I'm not saying it's the same as acknowledging service of proceedings, but it is giving us the opportunity. Assume we do have a defence based on that the award was procured by fraud. The purpose of the order is to give us the opportunity to come to court and say, sorry, you can't do that. Yeah. And so that's the point I'm making, that it is the service of the order that gives us that opportunity. And that's the reason why the court requires parties to, or it is part of the rules that requires the order to be served.
I just want to see, your case, as I understand it, on this kind of procedural aspect, is that there's nothing in 6218 which requires the court to do what Mr. Justice Teare did in this case, adding on to his order that it's not to be enforced until 2 months after service in accordance with his service. There's nothing that requires that, is that right? So your point is that if, as you accept, the claim form itself does not have to be served, and if a judge simply acts in accordance no further than with 6218 and dispenses with service, that in effect the enforcement, there's nothing in the statute or the rules of procedure which would prevent enforcement of the award without any sort of service at all on the state. Is that your point?
Precisely it.
And you say that is even more ridiculous.
Well, is that really the case? Because 6218(9)(b) expressly contemplates that the award cannot be enforced, must not be enforced, until after any application made by the defendant within the period here, the 2-month period, has been finally disposed of. So that contemplates that the possibility of the defendant making a...
Yes, that's true, but that's after service of the order.
Well, I agree.
And
your point is that if you can dispense with service, the only protection that's available, which is a procedural protection, doesn't apply.
My Lord, I fully understand your point. If we're not dispensing with service, I mean, that's the next point. But if you dispense with service, we don't even get into subsection 9.
No.
That's the problem here, that you are left, and it's a point that was very neatly put by Teare J in the Singaporean case, the Van Zyl case, where he says the alternative to relying on section 12 or having section 12 applied to a case like this is that you are left with no ground rules as regards the service or what is to be provided in the order when it comes to the issue of, well, do we require it to be notified? Is it to be service or not? And that is part of the problem. I mean, one of the conundrums here is that it's conceded on the other side. Assume we are within section 12.1 and that the order on the face of it has to be served by reason of section 12.1 of the State Immunity Act. We then get to the position that if you are not, if you don't have to serve because the power to dispense with service exists, then you're left with virtually nothing. You don't know what you have to provide. You are left with an alternative service situation, which is what we had with Mr. Justice.
Well, that would
Teare.
be true. I mean, forget an award against the state, but an award against another commercial counterparty. I mean, it's not suggested that the power of the court under 616 or 620, it would be 628, I think, to dispense with service of the order or make another order, an order for alternative service, something of that kind, couldn't be exercised in an appropriate case. And the practical effect would be exactly the one that you're referring to.
Well, the point I'm trying to make is that it's conceded here that alternative service is not open to the court. That's conceded if we're within section 12.1, because you've got to make service, and so you can't bring yourself within the first limb of my learned friend's argument. You can't have alternative service, but you can dispense with service, which seems a strange situation, because that is a more draconian, I call it remedy, the wrong word, but solution. It's a more draconian solution than alternative service. And what we get with Mr. Justice Teare's order, actual order. Now I'll show your lordships it while we're on this, just before we rise.
Well, we're now 1 o'clock. Do you want to do it now, or do you want to do it when you come back?
Well, maybe while we're just on this point now, because it is very short, if I ask you to take the supplemental bundle, please.
This is your point about paragraph 5 of the order, is it?
Indeed, my lord, yes.
The courier, the claim form, and the associated.
Tab 1, page 2 of the supplemental bundle, my lord.
So what are you looking at now here?
So, well, just to show your lordships, this is Mr. Justice Teare's order in this case. So you have the permission to enforce the arbitration of order, paragraph 1. Paragraph 2 is not relevant for that. Paragraph 3, pursuant to section 101(3), judgment be entered. Then 4, you have the permission to dispense with service, which is fine up to that stage, subject to the arguments, obviously. Then 5, the claimant is to courier the arbitration claim form, this order and the associated documents to those various addresses. Now, why is that necessary? And what that is alternative service, effectively.
No, it's not. It's ensuring that the order is brought to the attention of the people who were dealing with the case in Paris. Because that's the law firm who acted for your clients in Paris.
It is, my
in
lord.
the arbitration.
It is, but it is, in its practical effect, you've got a dispensing with service, but what we're achieving is effectively notification by way of an alternative means, alternative service, which everyone concedes you're not allowed to do. So that was the point I wanted to make at that stage, and that's probably a convenient moment.
Yes. Could I just say I don't seem to have tab 1 either in the supplemental bundle. Of course I have it in the judgment, and perhaps I could be provided with a copy of that.
Thank you. Now, I'm just concerned about the timing here, because you've got to deal with the respondent's notice as well. So we've got to get that all done today. There's no question of going over tomorrow, and I don't want to have any further written submissions. So I think over the short adjournment, could you please have a word about how you're going to split up this afternoon with a view to finishing at the latest at 4:30?
We'll speak, yes, obviously. It's a bit difficult. I've got quite a lot to say, obviously.
The 1 day time estimate.
What time?